So, welcome back. I am thrilled to introduce our next speaker, Mary Vandenack, who is presenting third-party trusts are no longer the asset protection safety net we once thought they were. Mary, we are so excited to have you here today.
Thanks so much, Hannah. So, as mentioned, I'm going to talk a little bit about just designing third-party trust with a little more view to asset protection. Historically, if we were drafting a third-party trust, I might tell a client, it's a third-party trust. You don't have to worry about asset protection for beneficiaries. It's a different beast from the self-settled trust. Well, that's changed quite a bit in the last few years. So that's the focus of today. So first of all, what is asset protection? A lot of times when the word asset protection comes up, people will think, oh, we're just talking about a domestic asset protection trust. And that's not the case. There's a lot of basic forms of asset protection. It's about arranging access, ownership, control, and management of assets. United States Supreme Court back in the 1800s said it's perfectly appropriate and legal to go ahead and pursue asset protection. So the question is, who needs asset protection planning? In general, this is a discussion I have with all of my clients these days because anybody can benefit from asset protection planning. Some of them, it can be a very basic asset protection, but I always include it in terms of my estate planning. Business owners are great candidates, especially those in high risk industries. I have a client who owns, one of the ski areas, and they also have several other activities related to that. And there's practically a lawsuit a day in their industry. So we do a lot of, high tech asset protection planning for them. Those in high risk professions, professionals, real estate developers, trucking, engineering, private aircraft pilots. And actually in the recent years, I've represented quite a few people that own jets. And say if they have a jet ownership interest, then they should be considering asset protection planning because there's a huge liability exposure if you're complying with, say, Part 91 and you should be complying with 135 or whatever the case might be. So we kind of have a growth in litigation. There's some expectation that that'll be a growing area. So some of the primary causes of liability, obviously medical debt has long time been one. Given the challenges with insurance these days and the coronavirus, we could probably expect to see that increase. We're seeing a whole lot with real estate landlords and tenants. I was involved in a call recently about, that we have these rules preventing evictions. On the other hand, we have landlords who are dependent on that income, not necessarily pockets of wealth. How is that all going to work out? So that's going to be an interesting area, and some of those on both ends, we may need to be looking at more asset protection. I know I'm doing that with my real estate investor clients right now. Building owners in general, we're a tax-focused law firm, but boutique here, and so we get a lot of calls on taxes, get involved in a lot of disputes, issues related to divorce, healthcare professionals. Everybody thinks about malpractice, but some of the bigger exposures I've seen is for inaccurate auditing, Medicare issues, things like that. So I always start with the foundations rather than jumping right to the asset protection trust. And the basic foundation is just a basic, good, solid estate plan. And I've learned, one of the things that's really an interesting experience in my career is the whole concept of, what is somebody's objective. So I've had clients come in talking about asset protection when what they're really doing is getting ready to file for divorce. So I had some clients come in, and it was actually the guy in this case driving the discussion about estate planning and shouldn't we split the assets. And I just picked up the dynamics of that, handed them a conflict of interest waiver, and they left, didn't do their plan, and filed for divorce 3 months later. But that raises one of the things in terms of, the estate plan design and asset protection is being careful when we're transitioning assets about what assets we're moving where. Insurance options, I always start with insurance. Sometimes people will use their kid or their friend for their insurance advisor, not really go through the policies and being clear about their risks and issues. The other thing is state exemption. So my home state is Nebraska. Nebraska has very ungenerous exemptions. So one of the common things that I work with is clients that are happy to move to Florida, Nevada, and Texas. That's a regular call. This year, it's been about moving out of the country, but historically, it's been moving to a state with better asset protection, Florida being one of the favorite jurisdictions from here for the unlimited homestead exemption. State law, consider state law generally. So again, the exemptions vary, income taxes vary, how things work varies. LLCs is another area of asset protection basics. So again, I'm in Nebraska, which is not super protective. It's not uncommon for us to look at forming an LLC in a different jurisdiction. Privacy in an estate plan is another basic way to enhance asset protection. So one of the things I talk about in trust is there's this historic approach to simply naming trusts after the client, or the same thing with LLCs. One of my basic asset protection things is simply use a name for your trust that isn't your own name. So you can use whatever. One of my favorite is the Packers Trust, but they lost last week, so I'm sad. So we'll have to come up with Mickey Mouse or something like that. A business succession plan and or business exit plan, which Vanetta just spoke to. But having a plan is a basic asset protection, covering from the asset protection perspective. We look at taxes, what if somebody becomes disabled, what dies. What was great last year was with the coronavirus, I had clients, we were a little bit too busy. So we represent a lot of essential businesses and clients, and everybody all of a sudden cared about their business succession plan, their asset protection plan, and their estate plan. There's certain assets that have basic asset protection that varies greatly by state law. I do have a practice that's pretty much, we're licensed in quite a few states, and I do a lot of consulting in different states. So we're looking at different state laws, and what I know is enough to say, okay, there's a huge, last year I think we worked in a good chunk of states, and my realization is two things. One, not only do state laws vary, but they change all the time. So when it comes to asset protection, trust law, tax law, I don't touch a state without making sure we review all of those and what kind of protections are going on. But I always look at, is your home have any exemption? Does life insurance have any exemption? Is your retirement account protected, and to what extent? So that's another of the basics. Marital agreements, sadly, divorce is still common. And as I understand it from my peers in that industry, the divorce rate's up. So marital agreements, you can do pre, you can do post. There's a variety of different things that will help protect. I'm kind of an advocate of separate assets in terms of some of the asset protection that you get from that. With respect to trust use as asset protection, the domestic asset protection trust comes up all the time. It's the cool topic in the area, and the foreign asset protection trust. But that's not what I'm talking today about. I'm talking more about your garden variety revocable trust that you create that will become irrevocable on death. So a lot of what I talk about really relates to what happens on death at the time, because obviously if it's revocable and amendable, you can change it any way you want while you're alive. I actually lost several clients to the coronavirus here this year, and I had several clients who got really sick. So it's kind of become, okay, this really matters because it can happen suddenly. I had, a 38-year-old who became ill and ultimately died from the virus this year. So it's been a reminder for a lot of people. So historically, again, I would tell a client, when we create this trust, it's a third-party trust, not a self-settled trust. And you as a result of that third-party trust status, you have some asset protection. Well, that's changed a lot over the years in terms of some erosion to that. And some of that's from the movement towards super flexibility. So I'm not going to talk a lot about, so this topic is the estate interest in divorce, because Sharon Klein did an amazing job of covering that in the story I told before. So if you happen to be looking at the slides that were included in the materials, I actually submitted an updated slide deck at the final hour just to make sure that I wasn't super redundant of some of the concepts of Sharon Klein. And I also sent in a paper that includes some coverage on the tax issues. I'm not really getting into any of the tax issues in detail today, but that there's a couple of those things covered in my paper. So I'm not going to talk a lot about the trust interest in divorce. I am going to mention this one case, and it was actually out of my home state, which was interesting. And this is historically gifts of property. If you make gifts or you give it, inheritance are considered separate property. So we had this case in Nebraska that said, well, at the end of the day, if you have somebody actively running the business, then the growth in that asset is going to be subject to marital division. I just mentioned this in this case because a lot of times we think, oh, separate asset, we're going to give it by, we're going to put it in a trust, so it's going to be safe. So if we, are subject to this law, or this becomes, and I think this case was wrong, by the way, and I've fought in regard to that. But I have another client who had received gifts of a business back in like 1962. So those gifts I didn't even do, but we did the analysis. So I do a lot of forensic, I have an accounting and finance background. So I do some forensic work. So we did some forensic tracing on those. And the value of the business was next to nothing at that time. It's worth a huge amount of money today, right? So all of a sudden we're like trying to, and his wife files for divorce, and we have this case out there. So I'm just kind of pointing that out, and this is a trend to really watch in terms of marital assets generally. And as Sharon talked about, it's really important that the big issue is it a property interest or is it an expectancy? That's the whole key. And the key to whether it's going to be a property interest versus an expectancy is, does the beneficiary, this is the question, does the beneficiary have a right to compel distributions? And in general, if the answer to that question is yes, then you have a good chance, at least in some states, of that being considered a property interest. And when I say in some states, as somebody who's helped a lot of people move over the years, I'm really aware of the fact people move. And so when we draft trusts, instead of just saying, hey, I'm in Nebraska, they're in Nebraska now, they might be in Florida in 2 years, they might be in New Jersey. I don't know where they're going to end up. So I try and draft trusts in a way that withstand moves. So I just call those kind of, it doesn't matter where you live. Let's talk about the principles that apply. And I have to mention, there's a great article in Trust and Estates. There's one by Sharon Klein in there, by the way. So in the January 2021, along with a great ad by WealCounsel. So I was flipping through, just making sure I was up to date on all the latest stuff, and opened the January 2021 issue. WealCounsel ad, Sharon Klein in that. So great topic, but there's also an article that talks about best jurisdictions for the DAPs. But what it does very nicely, it doesn't just talk about the jurisdictions, it gives a great backdrop. And I have it in one of my slides, so you'll have the site on that. But just talks about why there's been this erosion in terms of the discretionary trust. Sharon talked about these cases, so I'm going to go past those. But exactly what is a discretionary trust? And so under common law, and this is kind of what's happened in terms of the erosion, that we basically had, if you had your standard language that said, trustee has sole discretion to distribute. But what you then did was modify that language by saying, well, the trustee has sole and absolute and unfettered and complete discretion to make distributions in any way the trustee might choose. But then you added a modification to that language that said, oh, by the way, the trustee shall consider the health, education, maintenance, and support, so your HEMS standard. Well, under the restatement second, that language would have been a discretionary trust. And if you're clearly a discretionary trust, it's not going to be a property interest. It's going to be a mere expectancy. Then along came, so a little bit of the Uniform Trust Code, some cases in various jurisdictions, but the restatement third. And restatement third was actually, it was adopted, I think, 2003 or 2004. But so it's a while ago, it's been out there. But over the years, you've started to have states find ways to go after trust, either for creditors, whether they're, in a divorce, or any other type of creditor. So, and there's the site. So it's Merrick Worthington Sullivan. They do, I think they write that annually, and it's a really good article. They always run through some of the backdrop. And again, it's best site is for DAPs, but what they do great is cover general asset protection principles. So the asset protection from a discretionary trust, and it's just really important to keep in mind that the discretion you get from a distribution standard is not the same as a spendthrift trust. So sometimes I'll talk to somebody and it's like, well, I have a spendthrift clause, this is no problem. But if you have a spendthrift clause and then you have a HEMS standard, depending on what state you're in, you may have lost the asset protection value and converted at least some interest into property. And remember, courts are looking at different interests. They might look at an income interest versus the underlying principal interest. In some cases, they look at both. So you have to be careful that, I actually design like my principal and income. I never put them in the same sentence anymore. I used to say the trustee, I always separate them kind of for the purpose just to make sure I'm thinking through exactly what my income distribution standard is and what my principal distribution standard is, and being really clear about the difference. So that's, and then there's the spendthrift trust. So the spendthrift trust, again, that's simply a trust that includes a spendthrift clause. Spendthrift clause prohibits the assignment of a beneficiary's interest in trust. Okay, and there's pretty much for a long time you could see, I used to collect these, and it'd be in Nebraska, so we call it kind of that there's only so many forms. So, we live in a metro population of 1 million. So most of the law firms here come from, one of about 4 predecessors. So there's 4 different forms to the extent we're not using a service, which most people are switching over to our services today, which just plain makes a whole lot of sense. But you would see this spendthrift clause on this slide in almost all of the different variations of the clauses. And so what's happened is if you have a trust, you have the standard clause, you make no edits to it, and then you have a distribution standard that has hems, you risk losing the asset protection of that. Spendthrift clause has typical exception creditors. I'm not going to spend a lot of time there. Sharon talked about those, but I did add a note to keep in mind what we call the federal super creditors. And there's a case, United States v. Kraft, that talks about it's a bundle of sticks analysis, and it's worth a read to read this case. But what they do say, does the debtor have sufficient rights to constitute property that can be attached for a tax lien? And they looked at several different property interests. They compared tenants by the entire discretionary trust. The ones that are considered, if you have this with respect to an interest, use of property, right to exclude third parties, and right to share income, that property, your interest in that property may have, the sufficient rights that it's property for purposes of attachment. Now that's, at this point, that case is in the federal super creditor mode, but as you watch this erosion by states, my concern would be that you would see that, come along in other states. The win for the spendthrift clause in 2019 was the In re Cameron Gift Trust. What I love about this case, it was in South Dakota, my friendly neighbor to the north, and definitely a state worth looking at for asset protection, even if you're on the east or west coast. But we had a California, so somebody who had lived in California, her dad had created a trust for her. She got divorced, changed the size of the trust to South Dakota. The California court said, hey, spousal support, child support, and attorney's fees must be paid directly from the trust. The South Dakota court said, nope, not happening. So super important to note, this was not a self-settled spendthrift trust case. So if you're following that line of cases, there's been some challenges and successes there, but this was, a third-party trust. South Dakota said, nope, you're not getting the assets out of here. So that's one of the reasons I like situs change provisions in my trust. So a loss for the spendthrift was United States v. Harris. And this is the example I talked about where you have to be aware that you can have if you have a discretionary trust that allows distributions, doesn't matter if you have the spendthrift clause in there. So you've really got to attend to the distribution standards in any of the trusts that you draft these days and really look at those. Again, I like to break out the income versus the principal. So that spendthrift clause does not overcome a property interest. So it's a different factor. Another thing that I talk about is material purposes. And the reason material purpose is important, so once upon a time, again, as I look at some of the old documents in my files, I see these, well, the primary purpose of this trust is to take care of my spouse. And the secondary purpose of this trust is, and it's the same in every document that you look at. And so it's like, well, what is actually a material purpose? That just becomes just a template. So even to the extent you're using a form, which most of it definitely start with a document, and these days maybe not drafted personally, but we're modifying it, is that what exactly is material purpose and how does it matter? So one of the trusts, and hey, this was actually out of my home state as well. So I don't often get to quote cases in my presentations from my home state. So when I get the chance and one fits, I like to do that. But this was a case where, and I'm sure anybody who's been doing this for more than a few days has had this experience, mom or dad dies and trust beneficiary can't get enough money fast enough from the trustee that mom or dad appointed, and so start seeking a change of trustee. And we've actually ended up, sadly, a few times over having litigation in this area from beneficiaries having big fights over who they wanted to name as a trustee. And so in this case, trust beneficiary wanted to get rid of the corporate trustee, wanted to name her spouse as her trustee instead. And the deceased settler's attorney, and I spoke to the WealCounsel previously on testamentary intents, which I'm also pretty avid about. And so I loved this case in that the settler's attorney said, hey, the settler really intended that these assets be kept in trust for an additional generation. And so the court ruled, okay, this is a material purpose, and so we're not going to let the beneficiary seek this trustee change. We're going to keep these assets in trust. So spendthrift clause is a material purpose. One of the things that I do, so the Uniform Trust Code says, okay, that a spendthrift provision will be presumed to constitute a material purpose of the trust. But two things, you have courts interpreting these provisions, and you might be in a state that doesn't have the Uniform Trust Code or has modified it in some way. So I very specifically in every trust make sure I specify that the spendthrift clause is a material purpose or asset. I had a paragraph tell my trust about asset protection being part of being a material purpose of my trust. So one of the things that flexibility in changing trust provisions is growing. This can be used both to the advantage and disadvantage of asset protection and tax purposes. Some of the flexibility came from what I refer to as rather the bipolar nature of the estate tax exemption for the last many years. Once upon a time, I used to make predictions. I make absolutely no predictions about what's going to happen to the federal estate tax in 2021, even though others are predicting that we're going to have a retroactive reduction. I don't know. I feel like I have to tell clients that's a possibility, but I'm certainly not going to say I think it's going to happen because I really just don't know after the many years. The historic doctrine, the Claflin doctrine, clear back to 1989. I love the fact that this case was out of Massachusetts, and you'll note that it's the Massachusetts cases that are now having interesting interpretations of trust and sort of seeming to favor that trust interest in third-party trusts or property interest or property rights rather than expectations. But this case from 1989 basically said, hey, you cannot do a modification or termination of a trust if that's contrary to a material purpose of the settler. So this is a long-standing principle that said we do kind of care about why the settler created the trust in the first place. And as you know, again, whatever, I don't judge. Some people love the flexibility, some don't. I personally have a little bias towards the settler in terms of they're the ones who paid me and hired me to draft their documents. So I actually like to protect their intentions. I do like to have sufficient flexibility that if, one of them was asset protection or, saving estate taxes, we can do appropriate modifications. But in that case, beneficiary sought to get rid of a trust, and prior to the date of termination, court said, can't do it, and this doctrine stands. So then what we had happen is the restatement third. Again, that's been around since 2003 or 4. Don't remember exactly which year, but it was sometime in one of those 2 years. And that restatement acknowledges a trend towards flexibility. All the flexibility that we have today didn't start all the way back on the date the restatement was adopted. It's kind of evolved since then. But the test restates the discretionary power conferred upon the trustee to determine the benefits of a trust beneficiary is subject to judicial control only to prevent misinterpretation or abuse of discretion of the trustee. The concept of material purpose still survives, but it's been modified a little bit. There's quite a few methods to modify irrevocable trusts, so decanting is the latest process. Again, Sharon talked about this in degree to some extent, and I can tell you that I have used decanting to enhance the asset protection of a trust. I think there's 10 states that have formally adopted. And in one of the recent issues of probate and property, and I think I have it in front, it was January, February 2021, is this is one of the things in doing this work for a living. I try and keep up as much as possible on what's going on with the uniform laws and where they're being adopted. But there's a nice summary, and you can actually just go to the Uniform Law Commission website as well. But the Uniform Laws update in that particular issue shows all of the different acts that are really relevant to estate planning and talks about who's adopted them. And it talks about the ones that are, in my mind, relevant to asset protection planning and trust. But it's also talking about, the Uniform Electronic Wills and the Electronic Notary Acts, which have become important to most of us this last year. And Nebraska was interesting in that camp. But so decanting is one process to modify. And the reason I bring it up in the context of asset protection is, again, you can use it to enhance asset protection or to diminish it. And super care has to be exercised because decanting can have effects on taxes too. And again, I'm not talking about that today, but that's just my footnote, is when you do any of these modifications, really have to back out to a big picture, because I will see somebody pursue a modification for one purpose without considering the entirety. The non-judicial modification, so Uniform Trust Code, to the extent that applies, you can do a non-judicial modification as long as it's not contrary to material purpose of the trust. If the settler's still alive, hey, you can agree. If not, trustee and all current beneficiaries must agree. That's judicial modification. But so judicial modification also in section 411. So some states aren't comfortable with the agreement, and so we want judicial modification to have a judicial modification, have a judge look at it and approve it. Other ways to modify the trust that have become more common include just in accordance with the terms of the trust. And so a trust can provide powers of appointment to different parties or other powers that are granted to an independent trustee or trust protector. Although this is an area, and I use that a lot, as you have the Uniform Directed Trust Act, so you have some states who are using restatement second for the rules, and you have other states who are adopting the Uniform Directed Trust Act, and the variations are different. I didn't realize how significant some of the variations were until this past year when we were working a whole lot of estates. But anyway, so you can put provisions in the trust allowing someone to make modifications to a trust. What I do is I break those down. So my language used to be more general in terms of can amend this trust for certain purposes. I've gotten a little more specific because of the different state laws on that issue and whether somebody can exercise that in a fiduciary or a non-fiduciary capacity, which you have to be really aware of, both from a fiduciary liability perspective, as well as the impact on the estate tax and gift tax consequences of any actions to amend. Powers of appointment. So most of us have been using powers of appointment in some capacity as long as we've been in practice. There's currently a Uniform Powers of Appointment Act that's been adopted in 10 different states. If you hadn't read it, it's totally worth a read, including the comments. Has some good things in it. I think that will continue to evolve. It's been introduced in some additional states. So again, flexibility and asset protection, the flexibility can be a great thing, but if you're increasing the beneficiary's control in some way, then you're going to limit the asset protection. So you have to be careful who has the rights to make any modifications, who does, because just that right to modify it in the beneficiary's interest can create an issue with the asset protection, and again, the tax protection provisions either. So use flexibility with care and always consider, and I know I repeat that, but it's worth remembering, consider moves to another state. The rule against perpetuities. How long can assets stay in trust? So the current rule, or the current trend, has become for most states to lengthen duration of the trust and start, we either have perpetual or near perpetual trust in many states. One thing to be aware of is that you have to be a little careful if you draft a trust, apply governing law in a state that does not have a unlimited rule, or has not repealed the rule against perpetuities, because then you think, okay, I'm going to move this trust to another state where we can apply the rule of perpetuities. Can't always do that. So you have to be, you can draft trust in most states in a way that is going to allow you to do that, but it's not a no-brainer. So when you draft a trust, make a really conscious decision about the governing law from the get-go. Again, a lot of times we choose governing law in the state of residence, but there's a lot of reasons not to do that, or to at least make sure you can change not just situs, but governing law. Directed trust. So directed trust is basically a bifurcation of the historical role of trustee. Different states do this in different ways. You have the Uniform Directed Trust Act, and if you read that, in a lot of states, there's actually a lot of fiduciary liability to some of the alternate rules in your restatement second. States, there's a little bit less. So again, to the extent you create a directed trust, really give care to where you're creating it and exactly what roles, how you're going to bifurcate the duties. It has a lot of great potential for asset protection. Things like, I like to use the distribution committee or a distribution trustee or a distribution advisor, depending on where I'm drafting, and have guidance and things like that that are going to help move that trust away from being a property interest. And again, if you want to know what the directed status of directed trust legislation is, it's all readily available on the Uniform Law site. Trust protector is a concept that, there's the trust director under the directed trust statute, trust protector in some other states. And as a generality, this person is somebody who can have a certain amount of powers with respect to a trust. And powers that I see often and used to give often to the trust protector were the ability to modify or amend so that the trust, and I would modify that, remains consistent with tax objectives, which I would identify. Ability to amend for scrivener's errors, that's a really useful provision because, that just happens no matter what format you're using to draft. The ability to add or eliminate the interests of trust beneficiaries, that has to be used with significant care in terms of the applicable statutes, because you might have a fiduciary and non-fiduciary, and for both asset protection and tax purposes, that makes a difference. Power to change the trustee, I often use that role for the power to change or add a co-trustee. The authority to veto or direct trust distributions. So again, if that's in a fiduciary capacity, that's not a power of appointment. If it's in a non-fiduciary, it might be under the Power of Appointment Act. So that's a provision I've reconsidered how I draft. Power to change or approve trust situs. The authority to interpret trust provisions, again, exercising care with that, is working with an attorney in New York on some interesting trusts this year. And he had a really good perspective in terms of, with all these roles, you have to be really careful. I mean, as an attorney, you might say, well, I never act as a trustee for any client, but I might be willing to act as a trust protector. And then you give yourself all these broad powers and you say, well, I'm giving myself these in a non-fiduciary capacity. And then we have a ruling comes up that says that was the fiduciary capacity. I think ultimately, and you see that in the Uniform Directed Trust Act, you can draft out of liability in some areas, but you just have to be super careful about that. So I've gone to more limited powers, and sometimes we'll create a way to appoint somebody who can have a certain power. I try and create the ability to make changes, but I don't want any broad overpower going on. Other roles in directed trust are the investment advisor, investment committee, distributions committee. You'll see other roles too. In Nebraska, so you have a lot of farm and ag, so we'll have things related to that. But the distributions committee is my favorite in terms of dealing with enhancing the asset protection of third-party trust. So just some ideas in terms of drafting. And so my approach to asset protection in your standard revocable trust and in my irrevocable trust started one day when I had a super successful 55-year-old guy in my office, and he brought his mom in. And he said, will you please explain to my mother that I need her to leave her assets for me in trust. She wants to give it to me outright. And she says, you know, Rick, you're super successful and you've done really great and you've managed your money really well. So I'm not at all worried about giving you these assets outright. And Rick looks at me and says, can you please explain to her that because I've been successful and because of the particular industry that I'm in, that is exactly the reason that I don't want her to leave me the assets outright. I need her to create a third-party trust for me so that I have some little nest egg that's protected, because everything else I earn. While I've used LLCs and I've used various asset protection, and I even have a self-settled domestic asset protection trust, there's issues with that. So what she can do is she can give me the gift that I can't give myself, which is a third-party self-settled trust. And that was, I had that happen like a couple times in short order several years ago. And I was kind of with the parents at that point. Well, they're 50 something and like, why not give it to them outright? We're usually looking at distributions at 25, 30, and 35 or whatever the ages might be. And when I started to have clients in my office bringing their parents requesting trust, I'm like, wow, I'm an asset protection person in the estate planning world, and I need to rethink what I'm doing. So if any of you still use these provisions that you say, oh, it's really common to see a provision that says 1/3 of the principal will go to my child when they reach the age of 30, 1/3 at 35, and the rest when they're 40. And you spend time discussing, and you might have a client in your office who has minor children, and you spend time having a discussion about, yeah, what's the right age? Well, the answer to that, who knows what the right age is, right? If your kids are, I have, a 26-year-old right now. I have no idea where he's going to be in life at 30. He was going to get married 2 years ago, and that blew up already. And so it's like, And a couple times in my practice, I've had somebody, mom or dad's dies. They go out, they're celebrating. They, get a DUI. They do a hit and run, or they get their inheritance. Spouse thinks, I've had this happen a couple times. Oh, now's the time to file for divorce because he just got his inheritance. And we find somebody who says, and you see that trend in the divorce law. So that got me to just say, does it really make sense to have conversations with clients about the right age to distribute assets to kids? And sometimes the answer to that, by the way, is still yes. But the assumptions behind that are just kind of, a challenge. And I've looked at that differently. So there's a lot of issues with those arbitrary ages. What is, the other one that I've had happen is somebody gets disabled shortly after distribution. So I talk about, well, okay, let's revisit that conversation. And so, asset protection, when I talk about it, it's a spectrum. And I actually have graphs of it that say, okay, there's like almost no asset protection on one end, and I call that at least the possibility of asset protection, and then there's more asset protection on the other end, and the more asset protection is, let's have a conversation about Delaware or Nevada or South Dakota and their and actually there's some of the other states that I think in an article here in Trust in Estates, a couple of the other states that were little dark horses are moving up on the asset protection list. And after looking at this, I'm personally going to go back and look at a couple more states that I had not been considering in my mix of asset protection. And one of the great things about some of these other states stepping up and stepping into that area is it gives more options, because you're going to have a better chance of having a state's laws apply if your client actually has contacts in that state. So to the extent clients of mine are from Nebraska, it's really common that they have a connection to South Dakota. So that's an easy state to pick. If you're out in California, Nevada might be a great state to pick. It just, and that really depends, right? But so it's nice to see other states stepping up in terms of that possibility. So what I've gone to in terms of my revocable trust drafting is to say to a client, well, if you were going to give this to your children outright, at least consider instead what I call the possibility of asset protection. So instead of giving it outright to your child or whoever the beneficiary might be, let's have a conversation about creating a life trust for the beneficiary. And again, I'm not necessarily talking about a generation skipping trust here, just a life trust for the beneficiary. You might want to add issue, you might want to make it a dynasty trust, but again, I'm not going there today. I'm just talking about, hey, let's create a life trust for this beneficiary. And what you do is say, well, instead of picking an age that you're going to give this outright, let's talk about the age at which the beneficiary might become a trustee of this trust and have more control under a directed trust or, a non-directed trust. But at the end of the day, we could have this trust share and we could name the beneficiary as a trustee. Okay, well, that lends itself to a little towards being a property interest. So that's why I call this the possibility of asset protection. And it might or might not work. I can tell you I've actually had it work a couple times over. So until I absolutely clearly get it, as opposed to giving it outright, I'm going to continue to use that strategy. What we do is rather than giving a general lifetime power to appoint the beneficiary's interest, we give a testamentary power to appoint. Again, if they're going to give it outright to the beneficiary, we're probably going to give it to whoever. If they're married, maybe to their spouse, to their kids, whatever. So giving them a testamentary power to appoint, a general testamentary, they can do whatever they want to at their death, exercises in their will. But what I can tell you is when I talk to clients about this, a really interesting thing happens. They really hate the beneficiary's spouse. And I'm like, well, okay, let's talk about that testamentary power to appoint. You can limit it to some portion they can give to the spouse and make sure some goes to the kids, things like that. And so it's not that common when I do this that the power is general anymore. It usually becomes limited in some manner. So that's one of the things that increases a little bit of the asset protection, and to the extent that you modify that power, it lends itself a little less to a property interest. One of the things I do is include specific directions to a trust protector or to somebody to remove a beneficiary as a trustee and to take other actions if the asset protection or spendthrift provisions of the trust are at risk. This has to be an active requirement. So if it's the beneficiary has the right to say, hey, I need some help because I just had my 10th DUI and I hit and killed somebody, and that's an actual case that I had, then this isn't going to work. So it has to be an active requirement on the part of the trust protector. You have to find a trust protector that's willing to have that role, but that's the role they have to be, because there's probably some monitoring that's required in that. But what you do is say, hey, trust protector, if one of these things happens, take my beneficiary off as a trustee or whatever other actions, which you need to outline the actions that can be taken in the trust. Anyway, my note is anytime if there's a sole beneficiary and he or she becomes the trustee, this is not any fail-safe. There's risk to that. So the more you kind of do some designing to consider some additional approaches to the asset protection, if there's an interest in it, then you can move it to a higher level. So one of those ways is a lot of times when I bring it up, clients are like, oh yeah, love that, but really don't want to have any limits. So then we talk about using one more share. One share is the super protected share, and we design that. Maybe we even have a different trustee. The second share, we say, hey, we're going to have very few limits on this, realizing that the possibility of protection on here may be very limited on very light end of the spectrum. When possible, have more than one beneficiary. Trusts have value here. So if you're going to create a life trust for, say, son or daughter or beneficiary, whoever it might be, that you might want to allow distributions to the beneficiary in issue or somebody else. But basically, if it's a kid and you're probably willing to have distributions to grandchildren anyway, you've just added beneficiaries. You can consider creative strategies to include additional beneficiaries. Trusts can include provisions these days that allow a trust advisor to add beneficiaries. So you have to be careful about that design again, but you can do that. That's become a strategy used for a variety of purposes. Use a sole discretion distribution standard. So Sharon talked about that. What I like to say is provide the trustee has sole discretion and then just stop. And that language should create a discretionary trust or, an expectation in most states. Any simple modification of that language is going to create the risk that, there's going to be some part subject to the some of the assets subject to creditors. Some settlers are very concerned about that. So what I will do sometimes is say, okay, well, let's give them a right to a certain percentage or certain dollar amount, knowing that they're not going to have asset protection. We'll create a support trust. I do avoid the health education maintenance standard these days. I use that in some cases, but more for tax purposes. If I've got a situation where, SLAT and they want the spouse to be trustee and I can't talk them out of that, then I'm going to use the HEM standard because I don't really have a good option, right? But anyway, simple modification to the sole discretion can create subject to assets. So consider a different standard or some limitation and make a knowing decision. Look, if we use this standard, we're going to have something that's going to be subject to creditors. So let's carefully craft it. So anytime you do create distribution standards other than sole discretion, think through how can I define this and clarify the scope of the trustee's discretion. Also, the material purpose provisions, I've gone to carefully crafting these, and not just for asset protection. I've talked about my love for preserving testamentary intents. So my material purpose provisions, again, I inherited a set of documents early in my career and basically just use that whole provision. But I think the difference between a good attorney and a great attorney is that what every provision in your trust means and what its impact is, and you can have a conversation how it might be edited. So if the long-term nature of the trust is a material purpose, then I say that. The other thing I have clients on a regular basis is they want to limit the amount that their beneficiaries are going to get. So I have a couple clients that say, hey, I don't want any beneficiary to get more than $2 million. And then we have a conversation because that generally changes over time. So I talk to them about, well, let's talk about if you have a greater amount, let's talk about, including some provisions about what is intended. And so, you can look at that as distribution guidelines or restrictions, or you can talk about that right with your distribution standards. And depending on exactly what I'm trying to accomplish will impact where I'll add some language on that or modify language in my documents. Unique and specifically designed spendthrift clauses. So again, most documents have basic spendthrift clauses. I always try and customize mine, at least in part, to match up the circumstances of the settler that I'm drafting for. Trustee provisions, to the extent, again, if you name your beneficiary as the trustee, even a co-trustee, they have a certain amount of power, it's more at risk. So, my preference is actually to use an unrelated trustee, but as you know, some clients are like absolutely still unwilling to do that. Even some of my clients with really significant amounts of assets want to use their, friend from Jersey or whatever as their trustee. And I'm just like, oh, okay. So what I try and do is, create some protections in those documents, recognize that that's a factor out there that despite my best efforts, I can't always achieve. Really think through the successor provisions. So, like some of our litigation, and I don't do the litigation, but get involved from the substantive perspective, but is about trying to have beneficiaries' name and successors. So I talked a little bit about that. I will use the professional trustee, a trust protector combination. That's, your safest, works really well. It creates a good check and balance most of the times that I've seen. So I've gotten to, I really kind of like that approach. The directed trust, which has become more popular, that's the bifurcated approach. What I use there again for the asset protection is that distribution committee. I've gone to using distribution guidance more than restrictions. It's kind of hard to say, well, if my son hasn't, I had one gal who drafted, well, if my son has achieved this level of education or this level of education or this level. And you can do that if you want. The trust is going to get really expensive. But at the end of the day, some distribution guidance. And when you start bifurcating the duties as opposed to one human being who you might or might not know having the say, the guidance does seem to work better. I've seen that in action on the trust administration end now and have become a fan of that. The adverse parties or committees to approve certain distributions. This is a strategy that you see commonly in your INGs. Some of the non-grantor trusts and they also provide asset protection, just kind of mentioning that, but that's one strategy that gets used. You have the ability to create a power holder with a power of appointment over some portion of the trust. Okay, this, again, design has to be careful. I'll tell you, with the Uniform Power of Appointment Act out there in state law, I'm still kind of looking at this and deciding how that works. So if you ask me a lot of questions on that, it might be, hey, I'm going to follow up on that as I think about it. But where at least I first saw this or used this was when you had the federal estate tax exemption go bipolar, and then you start to think a little bit more about income taxes, and you have, the trust assets, and maybe, like I've got a client right now with 2/3 of his net worth is in a super low basis stock. So, we're thinking about it in that, but you can also use these powers to enhance asset protection. And so the Uniform Power of Appointment Act, I've summarized just a few of the provisions there for you. But again, the important thing is, what is a power of appointment? And, so the fiduciary distributive power is not a power of appointment, but when it's a non-fiduciary power, it can be. So that's, again, I haven't decided exactly how I'm going to utilize that, but that's a factor worth noting, thinking about to the extent you use powers of appointment. Include trust provisions that contemplate divorce. Sharon Klein talked about that in detail, so I think that was very well covered. I love her stuff. Marital agreement provisions. So again, what I do, I have a lot of clients who are uncomfortable with the spouses of their beneficiaries, particularly an issue in the high net worth clients. I have a client whose son is married to a woman, and she actually lives with another guy and shows up on payday, gets a check, and then goes back to her boyfriend. So my client says to me, wow, I really don't want her to benefit. So you can always require a marital or premarital agreement. I do include some language in that. But what you can definitely is cover that in material purposes and your distribution guidance, and talk about that to help trustees make decisions about what they're doing with distributions, and to help make it clear that you didn't intend this to be part of the marital estate. That particular client of mine was do anything and everything to make sure that my son's inheritance doesn't go to the gal who's living with another guy. Include specific language regarding modification or decanting. So, again, I modify my language based on the client's objectives so that there's not, I always, have the standard language. Yes, that's great. But what exactly are we trying to accomplish? And, it's one of the big things that I'll see sometimes in documents is somebody does a great job modifying their distribution standards, but then allows blanket modification somewhere else. It's just like, doing an LLC operating agreement and requiring a supermajority for something, but then allowing a majority to amend the agreement. It does no good. So all of the provisions have to be thought through. I make like an outline of my trust before I draft so that I know where I'm going, make myself think through all of those provisions. The perpetual or near perpetual trust. On the one hand, one of my favorite trust and estate guys, who I discuss this stuff a lot with, says to me, do you have any idea what the world is going to be like in 100 years? And the answer to that question is, no, you know what? Good point. I absolutely have no idea whatsoever. However, the perpetual or near perpetual trusts do have an awful lot of advantages, and I can tell you I've used that rather regularly the last few years. It's definitely gotten asset protection benefit. Design trust to survive across state lines. So what I really try and do in my language, it's really common again to see somebody say, hey, my client lives in Iowa, so I'm just going to apply Iowa law. I refer to applicable law and draft distribution standards and things that are going to create an expectancy in any state, because that is, this year, I can't tell you how many of my clients moved or family members moved to get closer to home, all types of things like that. So I think through is, rather than just focusing on the laws of the state of the client that I'm drafting for, is really saying, okay, now what if they move to any of these jurisdictions, and what is that going to affect in my trust? Trust names and privacy, I've talked about that. And in addition to naming it, what I do is, one time I had a trust guy, I was all concerned, he was a hedge fund guy, wanted to protect his privacy, but then he signed like a tax statement on a deed that we were transferring that was scanned in and made public record. I'm like, oh my gosh, please don't sign anything. But we create agents of trustees or powers of attorneys for the transactions on these trusts so that we can protect that privacy. Change of situs, governing law. Again, I've talked about that. Always consider clients moving. State income taxes, that's getting covered in the next session. It's also one of my favorite topics. The attendance verification code for today is there on the screen. And 3D8, Cap D5. And my information, and feel free to contact me. I'm always willing to hear questions, take feedback. It improves what I do. I really enjoy collaborating with other professionals to improve what we do in general. So I really appreciate being here today. Thanks very much for listening in.
Thank you so much, Mary. For those of you that were looking for it, again, the attendance verification code for today for this session is 3D as in dog, 8D5. Let me repeat that because it's 3 lowercase d as in dog, 8 uppercase D as in dog, 5. So Mary, that was a really, really helpful presentation, and we have a lot of questions because I think what you've covered in the area of asset protection, I mean, really, it's applicable to the way we draft trusts in general without having to think about, those additional layers of asset protection. So let me start with one question, which is, do you see the beneficiary's possession of a lifetime power of appointment as compromising asset protection due to the control concerns?
I think that's definitely a risk, and it depends on exactly how it can be exercised, but I'd be careful with that.
Okay. And then if you draft combined principal and income distribution guidelines that make income and principal distributions fully discretionary by an independent trustee, do you think there's still value, excuse me, do you think there's still value to separate out the income and principal distribution provisions as you do?
If it's going to be solely discretionary, I think that's okay. That I partly separate them to remind myself to think it through, and just because there's some case law out there that does treat them as separate interests. So as you look at these things, you'll see some of the court cases will analyze the income interest, analyze the property interest. And so what I do sometimes is, even if and I almost always use sole discretion standards, unless, again, I'm doing something different. So I guess I should say there's a variety of reasons I don't, but I'll use sole discretion, but I'll try and make some difference between the property interest. So if they find some other way to attack that, I still have separated the interest.
Thank you. All right, the next question is, how can you make real property harder to find when deeds have to be recorded? At least in California, the name of the current trustees have to be on the deed.
So, okay, so we're actually licensed in California, but it's not me. So California itself, I'm not going to speak to California specifically. I'm going to speak generally, and someone in California can figure this out. But what we've done is name a trustee other than the settlor, and you can change trustees, right? So let's say I represent a variety of hedge fund guys and investment bankers, and they don't ever want their name to be found on any transfer anywhere. So we've done, name an entity as a trustee. So we'll create an entity, name that as a trustee. If that happens to work, we'll name somebody else as a trustee temporarily. will transfer under an agent. So, because that is the biggest issue, is when you transfer the real property and the name shows up somewhere in that process. So a lot of times, power of attorney to make the transfer, so trustees can generally name somebody to act for them. That's another strategy that we'll use. So power of attorney, different trustee, entity.
Okay, and I think you have mentioned this before, but again, what is the reason for not using the client's name as the trust? I know that's a very common practice for many people.
So I just have a lot of clients who are concerned with privacy. So again, I just happen to have a lot of clients who are in the financial industry. So say like I have, I don't want to name any of who they work for, but so works for a major international investment bank, doesn't want his name showing up anywhere for a whole lot of reasons. He does has a certain really high profile role. So that's a big reason. That's the most common reason. The other thing is just for asset protection, is that if you aren't using the name, so if you use the John Doe Trust and it's John Doe's Trust, when somebody, and you title real property in that trust name, it's not so hard to find. But if instead, like, I have some real property and I have it titled in an entity called Quint Van Investments or something like that. So if you find, look for me, you're not going to find the property that I own. So for a variety of reasons, that just makes it harder. So sometimes asset protection is about making it harder to find or harder to attach. So it's a layering process. So you just kind of create layers. That's, in the asset protection world. So you might create a trust and you create an LLC within the trust that owns some of the assets. It's layers. In California, for the California question, is where I've been most involved in, create lots of layers.
Thank you. Would you suggest that clients draft a letter outside of the trust for guidance?
I absolutely believe in the letter outside of the trust. So I talk about that a lot in documentary and testamentary intent. And so if you can do so much in the trust itself, but the letter that's outside of the trust and kept updated, so great documentation. And what I do is we actually have an automated notification process that we build into our system now. We don't really do any formal maintenance plans, but we do notify all of our clients once a year to consider. And that's one of the things we say, well, let's update this, or at least send an email to us confirming that these remain kind of what you intend. I particularly like the guidance outside of the trust if there's any like bad boy stuff going on, because sort of the last thing you want to see, and I had this happen once this year, is client dies and their trust goes on about, well, my son is a drug addict and blah, 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 and he's been a jerk to my new spouse. And that's all in the trust, right? So I encourage, take that out of the trust, put that in a letter, and when you feel better about it, you can rip that letter up, right? So we don't have to keep everything that you ever created that is like that. But in the asset protection context, I still think that you want some provisions in the trust that make it clear that it's a material purpose and that the spendthrift clause and standards, but I'd also create that documentation. That's really important in what I call an era of flexibility is great, but that can completely undermine your testamentary intent. So I do think documenting your purposes outside of the document itself is incredibly important.
Thank you, Mary. Can you tell us who you think would typically be included on a distribution committee? Certain roles or?
So that is all over the board. And what I like to do again is some people will have siblings be on the distribution committee. And I don't know, but I've been doing this for a couple of days now. And I had a recent estate this year where a family that I'd worked with for 20 some years and had never seen any bad blood. And I thought these four were going to rip each other's eyes out post death, right? So, and I have another case where gal is disabled, other kids are remainder beneficiaries. And I walked into the hospital room and heard one wishing her dead. So I'm like, okay, don't create documents that are going to create those kind of things. So distribution committee, I'll tell you what I have on my own for my son. I have one family member. So I have a family member who's aware of the situation. I have one other trust and estate professional who understands the distribution rules, and I have one close family friend. So that's kind of, generally what I use for myself and for my son is often what I'll suggest clients to at least consider. What you don't want to do is have them name somebody who's going to use that as a power tool against the beneficiary post-death. So sometimes it's somebody else.
Thank you. Can you answer this one? How much protection can be reasonably expected when the beneficiary is the trustee under the HEM standard? Does this depend on the state?
Beneficiary is a trustee under the HEM standard. I think that that's where you have to look at the income interest and the principal interest. So income interest, and it definitely depends on the state, but the income interest to the extent of a HEM standard, because that's ascertainable. So with that HEM standard being ascertainable, it's considered we can calculate what that interest is. So the income interest is definitely going to be subject potentially to creditors, again, depending on the state. So when I use the HEM standard, which I still do, I define it a little more than just saying health, education, and maintenance. I try and give some guidance to the trustee as what I mean by health, education, maintenance, and support. And you have to do that with care, but I'll generally add some additional language to that.
Okay, so then if a beneficiary has a withdrawal right, which accrues, for example, at age 30, would that eliminate any asset protection for the trust assets?
To the extent they have the right to withdraw, then at the age of 30, at the time they have the right, so it's when they actually have that right. That right is not, if they're 25 and that right's not exercisable right now, hey, they could die. And so you have to look at what the trust provisions say about what happens in those situations. But at 30, to the extent there's a clear right to withdraw, I think you have an asset protection risk. And again, that's a little variant by state law.
Thank you. There's some follow-up questions related to changing the name of the trust or having, a name that's not related directly to the grantor. So is there a concern that if multiple parties have the same trust name, is there any concern around, like, if 1,000 people all name their trust the Packers Trust?
Which would easily happen, right? So I probably used a bad example, but I'm still grieving the Packers' loss. So I typically would suggest actually that you use something that's somewhat unique. So avoid like the initials and what we'll do sometimes to look for that is we'll actually like Google, or we'll look at the entity names, which are kind of a good indication. So I suggest something that's kind of unique so that you don't avoid that, because I do think that could pose an issue. Obviously, there's other factors besides the trust name. And hey, right now, a lot of us use John Simmons Living Trust. There's probably a whole lot of John Simmons out there. So we'd have to look at the other factors identifying the trust. But again, I do encourage trying to come up with a unique name.
Okay, so again, as a follow-up in the same vein, if you amend your trust to change it to a hard-to-find trust, is there any way to avoid having to retitle all the property in the trust?
So what I do is, and again, if you don't retitle, you've just defeated the purpose of changing the name, right? Because if any of the assets were titled, so if you change the name of the trust for the purposes of obtaining more privacy, you're probably gonna want to retitle all of those assets. But if I have a situation where somebody has, got everything titled in the trust and they've done an amazing job and they have assets in 50 different accounts, the last thing I really want to do is put them through that. So it's an amendment, you don't have to retitle it, right? So it takes a little more work when you want to transition the asset because you have to at some point. So I do an assignment of all assets from the old name to the new name that covers it just in case. But for the most part, I have that fairly frequently. This year in the COVID situation, getting retitling done was a nightmare. So we came up with all kinds of like, well, let's try an assignment. Let's try But the assignment is the number one way I use. But again, you're going to want to retitle if you're seeking protection by changing the name.
Thank you. All right, so we have a question about what about putting the major assets in a separate trust for the spouse that has less risk of being sued? How do you feel about that as an asset protection strategy?
Putting major assets in trust, yeah, that's actually a common approach. So, and that question, I'm kind of listening to that going, well, what exactly do we mean? Are we trying to just say we don't want to give them outright to the spouse? That's going to be my assumption behind the question. So I want to have the assets protected. And I'm just going to share a story there. I have a client who lived in New Jersey. And at the time in New Jersey, you could do a wrongful death. You could have a personal injury claim followed by a wrongful death claim, which doesn't happen here in Nebraska. My client, grieving his spouse's loss, we had funded her trust, but he takes a left turn and he hits a investment banker who's making $1 million+ a year on Wall Street, who's in his early 50s. So first there was the personal injury claim, and then there was the wrongful death claim that followed. The only assets that guy had at the left, and I won't give you all the facts of that case, but if you want to know more, I'll share it. But this is when I became like, oh, wow, there's a reason for asset protection planning. This stuff really happens. The only assets we were able to preserve is the assets that his spouse put in a trust for him. So in general, putting assets in trust for a spouse is a good thing. It's asset protective. There's all kinds of ways you can do it. And, it's going to vary based on whether it's a first spouse, second spouse, whether you're trying to make sure that that goes to other beneficiaries and the spouse in the long term, and a whole variety of other issues. So there's a lot of strategies, and I'm happy to follow up in more detail on that.
Okay, and I know we're running short on time, so maybe just one more question. Do you see any advantage of Cook Islands over a domestic asset protection trust?
Really good question. And my good friend John Gottman in Florida would say, absolutely. And so I will tell you that I personally don't do the foreign asset protections. I have a couple guys in Florida, but there are times and reasons to go to foreign asset protection trust. I think, hey, look at the litigation in the US on domestic asset protection trust. We have some wins, we have some losses. We do have a lot of bad facts cases out there. So whether it's a foreign asset protection trust or a domestic, one of my best cases is I had a guy call me early when the asset protection trust came out. We set up an asset protection trust in his case in Nevada, and he put $1 million a year in there, and he did it without any creditors. But then when I get the call from the creditor who's, hey, I just got sued by 15, that's too late, right? And that, if you're that latter situation, John might tell you, then you better go to the foreign asset protection trust. But if you're doing it right and you have good facts, I think under the current state laws, domestically for asset protection, that you can do a domestic asset protection trust right.
Okay, thank you so much, Mary. I think this was very helpful. I know there are a few more questions, and I know you've offered to respond to our attendees offline, so we will get those questions to you. But thank you again for today. We will see you back in just about 15 minutes. Thank you, everybody.